This courtroom dispute quickly turns tense as a landlord accuses a tenant of refusing to pay rent while still living in the property. The tenant claims she was unfairly locked out of her previous apartment before finishing her move and says several of her belongings were stolen, including important personal items. Because of this, she argues that she shouldn't have to pay rent for the new unit she moved into. However, the landlord's attorney strongly challenges her claims in court. He explains that the tenant had already signed a lease for the new apartment and had enough time to move her belongings from the old one. According to the records, she voluntarily turned in her keys before the apartment was secured, which contradicts her story about being locked out. As the hearing continues, the judge begins questioning the tenant closely and notices several inconsistencies in her statements. Her story appears to change when the timeline is examined, and the judge becomes increasingly skeptical of her claims. With rent still unpaid and both sides presenting different versions of events, the judge decides the case needs to move forward to a full trial. What started as a simple landlord-tenant dispute is now turning into a serious legal battle that will soon be decided in court.
And they didn't help you. What do you mean by that?
So remember how we were talking about how I couldn't afford a moving truck and that they will figure out something for me.
Right.
They locked me out in the middle of moving. And when we got access, which was end of May, a lot of my stuff was stolen, including a firearm, all my small kitchen appliances, my daughter's brand new sheets, my security cameras.
So what do you mean they locked you out? I don't get it.
Like we didn't have access. Like they changed the locks.
On my previous.
Yes. I did not render the old keys. And also.
So in essence, I just want to shortcut this. In essence, you're saying they changed the locks before you got all your stuff out.
I don't know what to do at this point.
Your Honor, if I can add, I would respond, but I'd rather have Amy respond because she has direct knowledge of what happened, because I don't believe that's our position. And I also don't believe it's relevant to this case, but that's a separate issue. I think it's worth responding to.
Your Honor, that's absolutely not factual. She signed a whole new lease, and I don't think I don't think Ms. Lutkoff or anyone would volunteer us to pay for a moving truck or use my maintenance guys to move her belongings, which is what Ms. Vanek seems to be under the impression that we offered her in court. She was given plenty of opportunity. In fact, there was a lot of grace given here to remove her stuff. And in fact, she came in our office on several occasions saying she didn't have a babysitter. She had to work. Her boyfriend had to work, all these reasons. I locked down the apartment upon her signing a new lease, sir. She took possession of a new apartment, Your Honor. And yes, I locked down the unit. She did turn in keys to our box. And so I took possession of an apartment that she no longer had possession of, Your Honor. And she left belongings.
Was there stuff in there?
Yes, my stuff was in there. There was
and boxes, I have the keys right now. I believe.
I have the keys.
So what?
The keys are in my bag.
I can't say whether she kept a set of keys or not, Your Honor, but what I do know is that way later after the fact, after she's been in this other apartment for quite some time, she's bringing up issues of stuff that she wanted out of the old apartment. And at that time, I had already started a trash out, Your Honor. I mean, she signed a whole nother lease.
Your Honor, I think there was an issue.
I understand she signed a whole nother lease. But I'm just trying to figure out what period in time are we talking about?
I have a timeline. So
Your Honor, I'm going to just state for the record here that factually, just from a legal perspective, if she wants to pursue, she certainly can file an action for damages if she feels that her property has been damaged on another unit. But we're in court on this unit. And so I don't believe it's relevant.
Yeah, but this unit, Ms. Lutkoff, that's disingenuous because this unit only comes about because of the issues that were in the other unit. So to try to separate them out doesn't make much sense.
Well, I think it does, Your Honor, because she didn't remove her belongings, but obviously this is your courtroom.
Okay, but
I'm just
that may be a defense to what she's claiming if she didn't remove the items. That may be a defense, but to say it has to be a whole another separate thing, I don't think that that's true.
Well, I do, because we're talking about a certain property
Okay,
address.
then
None of
I'll
that,
take what she filed. I'll tell her to go up there, stamp it in as another case, and it's just coming back with this one. I don't know where that gets us.
well, I don't know what she filed. I mean, she didn't say anything in her filing, so, but that's fine. You want to consolidate it, I don't have an issue with that. We can provide you documentation
Well,
as
you
to
can
what
have an
happened.
issue with anything. All I'm trying to do is get to the bottom of this. Bottom line. That's all I want to know. And I want to know where I'm going to take this case. So she can have her objections. You can have your objections. We're going to do it my way. Go ahead, man.
All right. So the reason why we're here is because I feel like I can't trust their maintenance people because my stuff was stolen. I don't want anyone coming into my apartment.
Ma'am, you were at the point of a timeline.
Yeah. So the timeline is I think we did our court date like April 26th, I think. And that's when we dismissed the case, which honestly, I wish we had set things and whatever. And then that next week or that Friday or whatever they had to finish with the apartment, I think we grabbed the keys like that Friday. So then we started that weekend because I was working 2 to 10:30. So we were putting the kids to bed and then we were getting the stuff. Plus, like I said,
okay, fine.
Couldn't move it.
So how much time passed between the time that you got the keys to the new place?
It was like a week and 3 days. And
so
then we
10 days passed.
And we lost access for 3 weeks. We didn't get the.
Oh, ma'am, stop. You had after you moved into the other apartment, you had access for 10 days.
Basically, yeah.
And you couldn't get all of your stuff out in 10 days.
No.
Okay, that's going to be a problem for you. They can't hold the apartment open for you to go in and move out in that fashion. You don't get 30 days to move out.
I understand. It would have been quicker if we could have just had that one last day.
Ma'am, I'll be honest with you. If you're telling me, you made it sound initially like they locked you out, and that's all I was trying to get to the bottom of. They didn't do that. It seems like, and by what you're telling me, you get the other unit, you've got 10 days, and you don't get all your property out in 10 days.
Well, technically, we didn't even have 10 days. They only gave us a week, but.
Okay, and that's even my point. Yeah. My point is 10 days would be extraordinary grace to get your stuff out. Yeah. A week, maybe about normal. Mm-hmm. That you move from one unit to the next unit. Maybe
what
get
about the previous agreement that some help was going to happen?
Ma'am, I don't recall that being the issue.
Can we look over the transcripts, please?
The transcripts of what? If you want to order transcripts, you can.
I tried. I haven't gotten a response.
Your Honor, I have not received a request for any.
It was a month and a half ago, granted. Sorry.
No, ma'am. You made a request for transcripts to my staff?
Yes, I did. I called and then they told me to email her.
Email who?
Whoever, I don't remember the name.
Well, you're going to have to show me that email because I'm going to be honest with you. If you're telling me my staff did not respond to you or did not address that.
Okay, give me 1 second.
Sure. Ma'am, while you're looking for that, who was supposed to help you move?
I'm not sure. Apparently, I mean, it said that they will figure something out because I literally said I could not afford a moving truck.
Okay. So you go over to this new unit and you have not paid any rent in that new unit. And your justification for not paying rent in the new unit is because things got stolen from your other unit.
Yeah. So, and they said it was good to go. It's not good. It was not good to go.
Ma'am, you paid no rent. Nothing.
I don't think it's okay to steal someone's stuff,
Well, they didn't steal it.
except they did because we made an
You know
agreement.
what? Here's what we're going to do. We're going to set this for a trial. We're going to set this for a trial on an expedited basis. Because did you find that email to my staff? Because I don't believe that you're telling me the truth. Because, ma'am, I'm going to tell you what. When somebody tells me my staff didn't respond,
I did call up here. I will say that.
but you said you sent an email.
Yes, unless it didn't. Oh, it didn't. Well, I have it on here, but I didn't send it apparently.
I'm not going to make you apologize to my staff for trying to say they didn't
No,
respond. No, ma'am, I'm just going to tell you right now. Here's how I work. And my staff knows this. If somebody wants something from them and they're supposed to provide it, they provide it. If you come up in here and you tell me that my staff didn't do it, didn't order the transcript, that they didn't respond to it, you want to ruffle my feathers, you insult my staff. So
I don't.
I'll consider anything you're saying about that afterwards, just an apology to Emily.
Okay.
I'm just going to set this for, well, I'm just going to set it for trial. The final settlement conference is going to work. Give me a trial date on a Tuesday
I can't.
of this month.
Could we possibly set it for August?
No,
I
you have, ma'am, I'm not going to delay this out. You paid no rent.
Okay, but I have a class on Tuesday.
Ma'am, I get, we all have different things on Tuesdays. We all have different things, different times. I'm going to set it for trial. You've not paid them any rent. You're claiming that they stole your stuff. You're claiming that they didn't help you. Well, I'm going to get to the bottom of it, if that's what it is. So I'm going to set non-jury trial in this matter.
Are we
For July 23rd.
So does that mean like jury and stuff?
No, ma'am. No jury was requested. July 23rd, 2024. That will be at 9 a.m. That will be in person. Ma'am, you make sure that you have all of your witnesses, all of your evidence. We'll hear it then, and then I'll make my decision.
This courtroom case begins with what seems like a simple landlord-tenant dispute, but as the hearing unfolds, it quickly becomes clear that the situation is far more complicated. A tenant stands before the court, defending herself against accusations that she has been living in an apartment without paying rent. On the other side, the landlord insists that the tenant is simply refusing to fulfill her responsibilities under a lease agreement. What follows is a tense exchange that slowly exposes conflicting stories, questionable timelines, and a judge who is determined to uncover the truth. The tenant begins by explaining her version of events. According to her, the problem started when she moved from one apartment unit to another within the same property. She had been living in her original unit for some time, but eventually agreed to sign a lease for a different unit in the complex. She claims that during the process of moving from the old apartment to the new one, things did not go as planned. She tells the court that she was not given enough time to finish moving her belongings. In her words, the management locked her out of the old apartment before she had fully removed her property. Because of this, she says several of her possessions were left behind inside the unit. She explains that when she later tried to recover those items, many of them were missing. The tenant claims that the loss was significant. She states that personal belongings, valuables, and even a firearm were among the items that disappeared. From her perspective, the landlord's actions directly caused the situation. She believes that the apartment management should have allowed her more time to complete her move and secure her property. Because of this alleged loss, the tenant argues that she should not be required to pay rent for the new apartment she moved into. She feels that the landlord created the problem and therefore should bear responsibility for the consequences. In her mind, the financial dispute over rent is directly connected to the loss of her belongings from the previous apartment. However, when the landlord's attorney begins presenting the other side of the story, the situation takes a very different turn. The attorney explains to the court that the tenant voluntarily signed a new lease agreement for the second apartment. According to the landlord's records, the tenant agreed to move out of the old unit and into the new one under the terms of that lease. As part of the process, she also returned the keys to the original apartment. From the landlord's point of view, returning the keys meant that the tenant had officially ended her occupancy of that unit. Once the keys were turned in and the new lease was signed, the management treated the old apartment as vacated property. The attorney also disputes the tenant's claim that she was suddenly locked out. Instead, he argues that she had been given enough time to move her belongings before the transition took place. According to the timeline presented in court, the tenant had multiple days to remove her possessions before the apartment was secured. This contradiction immediately raises questions about the tenant's story. If the tenant had already returned the keys and signed a lease for another unit, the landlord argues that the management was simply following standard procedure by securing the previous apartment. In that case, the claim of being locked out would not make sense. As the hearing continues, the judge begins to examine these details more closely. The judge asks the tenant to explain exactly when she moved out of the old apartment, when she returned the keys, and how long she actually had access to the unit. At first, the tenant insists that she was locked out before she could finish moving. However, as the discussion continues, the timeline becomes less clear. The judge points out that certain records suggest she may have had access to the apartment for several days after signing the new lease. The judge presses her on this issue, trying to determine whether her claim of being locked out is accurate or whether it conflicts with the documented timeline. As the tenant continues to explain her situation, the judge notices that parts of her story appear to shift slightly when confronted with specific questions. This begins to raise concerns about whether the details she is providing are consistent. The courtroom becomes noticeably tense as the judge continues asking questions and comparing the tenant's statements with the information provided by the landlord's attorney. Another moment of tension arises when the conversation turns to communication with the court. The tenant claims that she had previously requested transcripts related to the case but never received a response from court staff. This statement immediately catches the judge's attention. The judge responds by indicating that the court records show that staff did in fact respond to her request. The suggestion that the court ignored her request appears to irritate the judge, who quickly challenges the claim. At this point, the judge seems increasingly frustrated by the inconsistencies appearing throughout the tenant's statements. Despite the disagreements about the previous apartment and the missing belongings, the judge brings the focus back to the central issue that brought the case to court in the first place. The tenant is currently living in the new apartment, but according to the landlord, she has not been paying rent. From a legal standpoint, that issue carries significant weight. Even if there is a dispute about what happened in the old apartment, the lease agreement for the new unit still requires rent payments. The landlord argues that the tenant cannot simply stop paying rent because of an unrelated complaint about lost belongings. The tenant, however, continues to insist that the two issues are connected. She believes that the landlord's actions regarding the old apartment justify her refusal to pay rent for the new one. At this stage, the judge must decide how the case should proceed. Rather than issuing a final ruling during this hearing, the judge determines that there are too many unresolved questions. Both sides are presenting different versions of events, and the court needs a clearer understanding of what actually happened. Because of this, the judge decides that the matter should move forward to a formal trial. The judge schedules an expedited non-jury trial and explains that the tenant will need to bring all relevant witnesses, documents, and evidence to support her claims. At that trial, she will have the opportunity to present her case in full detail. The landlord will also be able to present records, timelines, and any other evidence that supports their position. During the trial, the court will carefully review everything presented by both sides before making a final decision. As the hearing comes to an end, it is clear that what started as a disagreement about moving apartments has evolved into a much larger legal conflict. The tenant maintains that she was treated unfairly and that her belongings were lost because the landlord prevented her from accessing her previous apartment. The landlord, on the other hand, insists that the tenant willingly ended her occupancy of that unit and is now simply refusing to meet the financial obligations of her new lease. With the trial date set, both sides now face the challenge of proving their claims in court. The outcome will ultimately depend on evidence, documentation, and whether the tenant can convincingly demonstrate that the events happened the way she described. Until that moment arrives, the dispute remains unresolved, and the final decision will be left in the hands of the court.